Hi, I am Ruth Hay, founding attorney of Renaski Legal, and this is my short introduction to contracts for the sale of goods. I am a business and transactional attorney with over 15 years experience of negotiating, interpreting, and enforcing many types of contracts for individuals, small businesses, and domestic and international companies. This presentation is part of a series where we discuss select causes of disputes and other liabilities that commercial buyers and sellers commonly overlook when entering into their business transactions. Formalities require me to mention that although I am an attorney, this presentation is only for education purposes and not to provide any legal advice. Also, this presentation forms part of Renaski's introduction series and is not a comprehensive or complete presentation on the topic. In a contract for the sale of goods, surprisingly, the most important provision is the quality of the goods being bought and sold. Without this, chances are the contract will not be enforceable. The contract should also contain other items such as the legal names of the parties, the description of the products being bought and sold, the pricing and payment terms, and all limits on warranties and liability, and any acceptance criteria and timeframes, and the other typical provisions. You will be surprised how many times I've received contracts that do not have the correct legal name of the parties involved, or are unsigned. Also, I frequently see contracts that literally have blanks, or do not address key items, such as the delivery date, or how much should be paid and when. Except for the product quantity provision, if a key item is not addressed in the contract may still be enforceable if the parties clearly intended to make a contract. In some instances, a court can supply reasonable terms for those that are missing. We will discuss this further later in the presentation. Often, merchants buy and sell their goods on pre-printed purchase order forms that contain standard terms and conditions. Sadly, it is also typical that these forms are either not applicable for the products being sold, the seller downloaded a form from the internet, or tried to use a form designed for another jurisdiction or type of transaction. Also, it's typical that these forms are one-sided and designed to only protect the interests of one party, while attempting to limit the rights and remedies of the other party. A conflict between the forms arises, and this is when most transactions grind to a halt and the lawyers rub their hands with glee. I strongly encourage my clients to have fair agreements and forms, so that the paperwork doesn't get in the way of getting business done. Transactions, after all, are the lifeblood of any business. In fact, the very name of my law firm, Renaski, reflects the golden rule concept, where Ren means how people should treat each other. Sometimes the differences in the paperwork need to be resolved when there is a dispute. The UCC has a mechanism where conflicting provisions fall away and are replaced by supplementary terms from the statutes or sources such as trade usage. These are called gap fillers. Typical gap fillers cover delivery location, delivery time frames, payment provisions, and warranties. To illustrate the operation of the UCC and its gap filler provisions, consider the following example. A buyer places an order for a power compressor from seller, a manufacturer of compressors, for $150, cash on delivery, in 30 days. The seller responds to the buyer by accepting the order expressly on the condition that the buyer agrees to seller's indemnification provision. The buyer doesn't read the response and is not aware of the new provision and doesn't communicate anything to the seller. The seller ships the compressor and the buyer accepts it, pays for it, and starts to use it. Then one of buyer's employees is injured using the compressor, and the buyer sues seller as the manufacturer of the compressor. The contract between the seller and the buyer agreed on the description of the goods, the quantity of the goods, its price, the payment and delivery provisions, but the new indemnification provision falls away. The gap is filled by implication, and will be resolved by a complex interaction of contract and tort law outside the scope of this presentation. Gone are the days when all parties to a transaction sit together in a conference room, sign documents, shake hands, and close a deal. Today it seems like most deals are closed via some form of electronic communication. There are state and federal statutes that recognize electronic signatures. However, electronic signatures are not yet enforceable in all states or for all types of transactions. For those states that do recognize electronically recorded information concerning the sale of goods, the information must be retrievable and in certain types of formats. The electronic contract does not need to be a single document and can be a series of correspondence or linked writings, for example, a chain of emails. However, emails do not always satisfy the signature requirement. Also, the writings must clearly refer to the same transaction, and taken together, they must document all the requirements of a contract. There is an exception to the signature rule where a writing can be enforced against the party who didn't sign it if all of the following requirements are met. Both parties are merchants, and within a reasonable time of the oral contract, one of the parties sends a written confirmation to the other, which is signed by the sender, and the recipient has reason to know of its contents and doesn't object within 10 days of its receipt of the confirmation. By failing to object to the written confirmation, the non-signing recipient is bound to the terms of the contract. After all, the purpose of the written confirmation was to confirm what had been agreed. Lastly, if a contract fails to comply with the UCC, it may still be upheld in court if the party being sued admits the existence of a contract, even an oral contract, if the seller has accepted payment, or if the buyer has accepted delivery of the goods covered by the agreement. The UCC requires a perfect tender. This means the delivery and the condition of the goods must be exactly as promised in the contract. If a carrier agreement is used to transport and deliver the goods, the seller need not see that the goods actually reach the buyer, but only needs to put the goods into the control of the carrier company and to make a reasonable contract for their transportation to the buyer. The seller also needs to tender the documents necessary to enable the buyer to take possession and to promptly notify the buyer of the shipment. If the seller has agreed to tender the goods at a particular destination, for example FOB buyer's factory, the seller must, at the destination, hold the goods for a reasonable time for the buyer to get the goods. Where a carrier company is not used to transport and deliver the goods, the seller must tender the goods at a reasonable hour and hold the goods for a time period sufficient for the buyer to take possession. The seller must give the buyer reasonable notice to enable him to get the goods. And if the parties have not agreed where delivery should take place, the place of delivery generally is the seller's place of business. Unless otherwise agreed, a sale of goods is for cash, which is due with the tender of delivery. Remember that in a sale of goods contract, the seller is obligated to make a perfect tender. So if the tender is not perfect, the buyer can reject the goods and withhold payment. The buyer is excused from paying because of the seller's breach. But what if the buyer pays without inspecting the goods? For example, Betty orders clothing from seller's website using a destination contract. The goods arrive in a plain brown box. Because the clothes may not be the right size or color or may be faulty, Betty needs to look at the goods before she can accept them. Betty either accepts the clothes by keeping them or rejecting them by notifying the seller that she doesn't want them. When goods are lost or damaged without the fault of either the buyer or the seller, who has the risk of loss? If the risk of loss is on the buyer still has to pay the full contract price for the lost or damaged goods. If the seller has the risk of loss, then the buyer has no obligations and the seller faces liability for non-delivery. There are 5 risk of loss rules. The first one is if there is a contract, the contract determines who has the risk of loss. The second is if a breaching party is liable for any loss, even though the breach is unrelated to the problem causing the loss. So for instance, the seller is 2 weeks late in delivering the products. Here, the seller remains liable even if the delay has nothing to do with the damage or the loss. If the seller uses a carrier to deliver the goods, the risk of loss shifts from the seller to the buyer at the time the seller gives the carrier the goods. And for destination contracts, the seller remains liable until the goods are delivered to the destination. And lastly, if there is no contract, no breach or carrier delivery, the risk of loss is determined by whether the seller is a merchant. The risk of loss shifts from a merchant seller to the buyer on the buyer's receipt of the goods, whereas the risk of loss shifts from a non-merchant seller when he tenders the goods. There are fundamental public policy obligations that are legally mandated to be included in contracts. The law is concerned with protecting a weaker party in a contract from one-sided and unfair terms. One of these obligations is for both parties to perform reasonably and in good faith. A warranty is not a promise that nothing will go wrong, but rather it is a promise to fix certain things that go wrong for a certain period of time. The UCC provides for 2 types of product warranties: express warranties and implied warranties. An express warranty is a promise or an affirmation made by the seller regarding a fact about the goods. For example, the seller makes a promise, describes the goods, or provides a sample or model of the goods to the seller. Sellers can limit the scope of the express warranties by specifying a duration, imposing conditions that will invalidate a warranty, or insert exclusive remedies for the breach of a warranty. Unless the parties expressly disclaim them, the UCC imposes implied warranties into sales of goods. For example, the implied warranty of merchantability is automatically added to a contract by operation of law when a person buys goods from a merchant. The warranty is that the goods are fit for the ordinary purpose for which such goods are used. The triggering fact for the warranty is that the seller is a merchant. If you remember, this means he deals in goods of that kind. For instance, Barbara buys a gold chain from a fine jewelry store, but her neck turns green. Can Barbara recover from the jeweler for a breach of warranty? Yes, she can. Another implied warranty is the fitness for a particular purpose. This warranty is implied in contracts from a merchant seller where the buyer has a particular purpose or need for the goods, and the buyer is relying on the seller to select suitable goods for that purpose. For example, Beth is a cowgirl, and she tells the clerk at a shoe store that she needs some suitable shoes to wear to an interview with a professional accounting company. The clerk sells her a pair of beautiful white leather cowboy boots with lots of bling. The interviewing accountants take one look at Beth's beautiful boots and immediately terminate the interview. Is there an implied warranty of fitness? Yes. Was it breached? Oh, yeah. Beth had told the clerk what her purpose was and that she relied on the clerk to choose suitable shoes for the interview. The seller knew what the purpose was, but still sold the white boots. To disclaim or modify an implied warranty, the language must be very obvious in the contract. You've probably seen a contract which has a couple of provisions written in capital letters. These are the implied warranty disclaimers and need to be read very carefully. With the exception of the phrases "as is" or "with all fault," a complete disclaimer of these warranties is unusual, since most buyers will not purchase goods without the basic assurances that these warranties provide. Courts will usually allow contracting parties the right to allocate liability between them, but the courts will not uphold a limit that is contrary to public policy or statutory prohibitions. In an agreement for sale of goods, where the greatest liability risk generally rests with the seller may want a limitation of liability clause capping their exposure to a flat dollar amount. Buyers often resist these clauses because they want a broad range of remedies available to them. The UCC reflects the general contract's damages policy of putting the innocent party where it would have been had the contract been performed. There are two relevant facts: who breached and who has the goods. There are four basic rules. The seller breaches and the buyer keeps the goods. The damages are generally the fair market value, if perfect, less the fair market value as delivered. Where the seller breaches and the seller keeps the goods, the damages are either the market price at the time of discovery of the breach less the contract price, or the replacement price less the contract price. Where the buyer breaches and the buyer has the goods, the damages generally are the contract price. And where the buyer breaches but the seller has the goods, the damages are either the contract price less the market price at the time and place of delivery, or the contract price less the resale price, and in some situations the seller can get lost profits. There are other approaches and remedies which we do not have time to go into in this presentation. I hope this presentation has been helpful to you, and please feel free to reach out with any questions you may have regarding it.